The chair. You want a chair?
Good chair.
There's one right here.
I got it.
So we'll be the only group with four judges.
Thanks. Perfect. Thanks. May all be seated? Welcome, everyone. Teachers, I don't think I've seen parents. We've had a great morning so far. We hope you have too. It's a huge pleasure for us to be here, and it's a tremendous honor for you guys to be here as well. So let's just start with a round of applause. It's great. My name is Emma Freeman. I'm a We the People alum from 2004, and I'm currently a third-year student at Harvard Law.
Good morning, everyone. My name is Jay Lee. I'm an attorney practicing in law.
Good morning, I'm Tim McKenna. I teach constitutional law and ethics at WPI.
Good morning, I'm Norm Shikochis, President of the Massachusetts Council for Social Studies.
And I'm Terry Yaffe, and I'm the Education Chair for the League of Women Voters.
And Terry will be your timer today, so she'll give you guys a 1-minute warning and then time at the end of the year. Yeah. Would you all introduce yourselves?
I'm Erin Haley, senior at Pembroke High School.
Hello, I'm Kevin Gately, senior at Pembroke High School.
I'm Brendan Johnson, senior at Pembroke High School. And this is our AP Gov teacher, Mr. Hall.
Great to meet all of you. So we're going to do 5 today, as you all know, and we're going to be asking you question number 2. So I will read you the whole question, and then you'll begin your presentation. So question number 2. The makers of our Constitution conferred, as against the government, the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. Do you agree or disagree with the opinion of Justice Brandeis? Why or why not? What protections against intrusions by the government does the Fourth Amendment provide? Why has the Supreme Court struggled to be true to the spirit of the Fourth Amendment while not restricting police in ways that render effective law enforcement impossible?
The Constitution includes the Fourth Amendment, which is meant to protect citizens from unreasonable search and seizure by the government. This amendment is necessary to protect the privacy of individuals. In the court case Olmstead v. United States, which took place in 1914, Roy Olmstead was suspected of running a bootlegging ring and had his phone wiretapped by prohibition officers. This case was brought to the Supreme Court, where it was argued that it was in violation of the Fourth Amendment because Olmstead's privacy was unnecessarily intruded upon without sufficient cause. The court ruled in a 5-4 vote against this argument because the officers did not technically search any of his possessions. Louis Brandeis was one of the dissenting judges, and he argued that the right to be let alone by government is one of the most important rights for a citizen to have. In order to protect this right, any unjustifiable intrusion by the government upon the privacy of an individual must be considered a violation of the Fourth Amendment, whether it involves a tangible or intangible item. The opinion of Justice Brandeis is correct and needs to be valued by the government. An individual should always have the right to their privacy. It is not the place of government to interfere with certain aspects of a person's life.
The detrimental effects of not having protection against unreasonable search can be seen in the colonial era. During this time, the British government issued general warrants for of assistance, which allowed soldiers to search a vessel or home without probable cause. This was a major intrusion upon the colonists' privacy. They have the right to do as they wish, with what they wish, as long as it's lawful, and the government should not infringe upon this right. These unfair actions of the British government led the framers of the Constitution to include the Fourth Amendment, which states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the man, the place to be searched, and the persons or things to be seized." This amendment protects persons, houses, papers, and other personal effects from unreasonable searches and seizures. In order to prohibit unreasonable searches and seizures, the amendment disallows general warrants and requires applications for warrants to be supported by probable cause. For a judge or magistrate, rather than the official serving the warrant, is required to determine whether or not probable cause exists.
In addition, the application for a warrant must clearly identify and describe the places to be searched and whom or what is going to be seized. All of this is meant to ensure that the government is intruding upon a person's privacy for a good reason. If it is not for a good reason, it is unacceptable and the government is abusing its power. For the Fourth Amendment, while the Fourth Amendment is meant to protect the privacy of individuals, it can sometimes hinder effective law enforcement. It requires law enforcement officials to submit an affidavit to a judge in order to obtain a warrant. If the judge decides that there is no probable cause, then the law enforcement official is not legally able to search a person or his belongings. Sometimes this allows individuals to engage in illegal activities, and law enforcement cannot legally seize them or their evidence. Although this amendment does sometimes make effective law enforcement difficult, it is necessary because it is the main law and that protects a person's privacy.
Thank you. I haven't asked this question at all today, but something early on that in your statement made it pop up in my thoughts. We have, not universally, but welcomed a greater role of government in our life, okay, in many ways. By asking or allowing government to take a greater role in our life, does that open the door for their greater intrusion in our life?
I believe that with this extended open door to government, it does involve a little more intrusion. We saw during the Iraq War, the Patriot Act, where President Bush enabled people with security to tap into private phones, which I feel is a big invasion of privacy. Listening to private conversations is a big kind of a downfall of that. And the government was, I was not a big fan.
Well, going along with what Brendan said, it's a two-way street because we open the door for our opportunities for the government to help us. Then it has to be expected that something is going to come of it. It's not that we can just keep our same rights as we did before we had more government within our lives. It is going to change.
I've got a quick three-part question. The first two are easy, don't worry. Olmsted was decided before the exclusionary rule was in effect.
Yes.
Would the same result happen today with the exclusionary rule in effect? You think? Legal conduct of the police? Maybe.
I'm not sure. Oh, it's a tough one.
If it was illegally obtained material, would that be the freedom of proposed and security thing?
If it was legally obtained, I think it would be fair.
Great. Now the tough question. Let's say Olmsted was guilty of murder, and they had evidence of his murder based upon illegal activity by the police. Should that material be kept from evidence, even if that meant Olmsted would be a free murderer, couldn't be convicted? What do you think? Should we let murderers go free when the police break the law?
Well, I think that's a basis of opinion on how we view our government, is if we're going to take a narrow approach and say this is what's happening, this is in the law, and we're not going to stray from that, or you can talk about it broadly and say, well, does the murder overcome the actions that the law enforcement took? I think it's a give and take that we have to understand what actions hold the most substance and how important those things are.
And a lot of times, usually police officials, they have multiple ways of obtaining certain evidence that can prove a person guilty.
You stated that there's a need for a warrant, that the general warrants were replaced by what we have now, which is a warrant that's supported by the police affidavit, for example, and even the judge in the determination of probable cause. When can searches be made or evidence seized without a warrant? Under what circumstances can that happen?
I believe under potential terrorist threat, I believe that you can stretch the law a little bit, in which you would maybe have less probable cause. You still have a valid reason to go in, but maybe not a specific warrant for it. You know what I'm saying? More of a broad general warrant, but not necessarily going guns blazing.
Well, going on with what Brendan said, I think it depends on who is impacted by the greater good. If the citizens are going to benefit from having something searched and not having a warrant, then I think then you have to take into account how many people you're helping besides hurting.
I also know that if an officer is in the pursuit of a chase, then they are allowed to enter someone's house, like, and if they see something out of the ordinary when they're doing, say, a search that they got a warrant for, like, say they got a warrant to go search for drugs, but they saw guns, they're allowed to obtain that item. And also, if they hear, like, a shout for help, someone shouting in a house, they're allowed to go in there and investigate.
So you mentioned how the Fourth Amendment covers persons, houses, papers, and other effects. I wonder how each of you thinks that might apply to social media like Facebook and Twitter, which certainly wasn't on the minds of the framers when they wrote the amendment. And how do you think the Fourth Amendment can apply to developing technology?
Well, I think social media goes under your, not personal belongings, but it's your own. That being said, I think it's a very like touchy subject because you can go with it either way. You can say, well, this is mine and that's how I took it, but you're under this big umbrella of somebody else. So nothing on social media is really yours. It's based on the company that is promoting what you're doing.
Public information, unless you yourself created that.
It's all the websites, copyrights, it's all technically their information once you put it up there. If you send a tweet out, it's under Twitter now, it's not your private thoughts anymore.
You're allowed to delete them, yeah.
What if you have your privacy settings on maximum on Facebook? Does that change what you were just saying?
I don't believe so, because you're still using that site, you should still understand that it's not in your head anymore, it's a thought that you put out on the internet, someone can find it if they have to.
You're making a conscious decision to post it where people can see it, or that it will be saved in internet records basically forever. And that, I think even anything that goes on social media is definitely subject.
Is it the,
Thank you.
Thank you. Good job.
Thank you all, that was wonderful. We're just going to take a couple minutes to give you guys some feedback before we head out. I thought you guys were excellent, and I especially liked the balance of your presentation. I thought you had a really well-distributed conversation. You talked about some court cases, you talked about some historical examples in particular, and then you were able to really bring it up to the present and talking about things like national security threats. And so it felt very well balanced. And I thought, this might sound silly, I liked each of your personalities. I really felt that you all were able to express your own opinions, and on an issue like the Fourth Amendment, which is extremely controversial, I really appreciated that, and I thought you each came through as individuals.
I also think you guys did a great job, especially with that second sort of sub-question, which is one of the toughest ones because you're talking about a bottom line for protections and law enforcement. They did a really good job handling that issue. With solid examples. I also liked the fact that you asserted your own opinions, backed it up with solid examples, and you didn't sort of take the easy way out on those tough opinionated type of questions.
Very well prepared, very poised presentation. Where you applied the Patriot Act in that earlier question was great. The way you came up with the emergency exception to the warrant requirement was great. Good thinking on your feet. Good job.
I would repeat all that's been said. I like the confidence that you exhibited in your answers, and how you bounced off, or picked up on what one of your colleagues had to say. I thought the answer to the question that I threw at you is a huge question about big government, small government in our lives and in politics and all of that. I thought you handled that better than most politicians that we listen to. Yeah, so thank you for that.
Thank you.